Now, I know that I've already heard from several of you that you testify a lot. How many of you have received a subpoena in the past of some sort? Okay, well, that's the majority of you. How many of you have testified in the past? Okay, and that's also the majority of you. Well, we're going to be discussing really protocols for testimony, what you can say, what you can't say from an ethical and legal perspective. And I was just looking to see if we had a whiteboard, and I don't see one. But if there is one around, it might be nice if we... Oh, I see there's one right back there. Yeah, on the back wall. Okay, well, we've got one right there. And I'm sure we can use that as needed. So one of the things that, believe me, not too many people outside of Summit Stone know about subpoenas, but you all know because it's part of the Summit Stone subpoena policy that I think is great, is that a subpoena is not an order to testify. It's not a release. You could call it a request, a very polite request issued by an attorney. And the whole idea is the subpoena will tell you where to go, literally, where to be, and what time you have to be there. It may say that you have to be in court, for example, on May the 4th at 9 o'clock. Or it may say that someone wants your deposition, probably not in your case. So it's more than likely going to be either a subpoena to appear and testify in court, or it will be a subpoena to produce records. Now, what do the rules provide about a subpoena to produce treatment records? That because they are privileged, mental health treatment records, and they're confidential, a release must accompany the subpoena. How often do I see attorneys comply with that? Less than half the time, truthfully. So just because a subpoena to produce records is being served perhaps on Summit Stone or perhaps on you, they're required to do it 14 days before they want you to produce the records, so 2 weeks beforehand. And furthermore, they want you to, I'm laughing because Jessica's writing down what we put on the board at the last presentation, which is great. We're definitely training you all, programming you all to be able to say in court, among other things, I don't have an opinion on that question. Your Honor, Your Honor, I do not have an answer to that question that you've just asked me, Judge. So anyway, I'm laughing because these are good points, and we want you to literally be trained today as to how to say no, I can't answer that question. But anyway, so let me go back. So a subpoena to produce, they have to give it to you more than 2 weeks before your deadline to produce the records, and they're required by law, by court rule, to provide you with a release signed by the privilege holder or the privilege holders. Now, how many of you got a subpoena to testify in court in a divorce case? Okay, so just one of you, and that would be Brooke, right?
Yes, thank you.
Okay, yes. How about dependency and neglect case? How many of you, if any? Okay, so several of you, 5 of you have gone to court on a DNN case. What other kinds of cases have you all been subpoenaed to testify on or to testify in?
Criminal cases.
Okay, criminal cases, go ahead.
To stop visitation with the grandparent.
Okay, grandparent visitation, which would be domestic relations case in any event.
Probation revocation.
Okay.
Sex offenders.
Okay, oh my gosh, okay. Do you do sex offender therapy?
I did that in El Paso County.
Oh, did you?
In the mid-90s to mid-2000s.
Okay, gotcha. So, the rules around the ethical standards and the legal standards for testifying would apply in any of these cases, is the point. But I did want to have a sense of what kinds of cases you're testifying in. So, we've discussed, the first basic principle about subpoenas, and that is, again, they don't compel you to testify or to turn over information. They're like an engraved invitation. Come on down to court, please. And in some cases, again, and bring with you your treatment records. So The, the fact is you need client consent to testify, and that then informs us as to what is the first steps that we take when you are served with a subpoena. Well, as it turns out, the first step that you're going to take, even before you contact your client to say, will you consent to me sharing this information by testifying in court as to your presenting problems and your diagnosis and your treatment plan and the progress that you've made, I mean the clinical issues. Besides that, we first want to talk about the fact that at Summit Stone there is a subpoena response form that you first want to send over to Jessica. So Jessica, why don't you discuss that? I know we don't have a copy of it that we can project, but still.
Those of you who have been subpoenaed are probably familiar with what I'm referring to, and if you are ever subpoenaed, you'll know what I'm referring to because I always send it along with the subpoena. But whether, so when you do get subpoenaed, it'll be through me via email. I send it to you and your supervisor and billing and Jess. And I ask that you return the subpoena response form. Something I'm changing this week is to return it within 24 to 48 hours. Because there's really important information regarding which clients are ours involved in the case, and it's been cumbersome to try to figure out properly which charts to import the subpoenas into, which charts need their financial eligibilities updated to reflect court testimony. So when you're documenting your prep time, documenting your testifying time, it can actually be finalized and eventually billed. So that that's an important piece of the subpoena response form. The other piece informs me if we have a release of information on file or not regarding the case. And Dennis is going to speak about what releases are count and which don't. So we'll touch on, we have an open ROI with Larimer County DHS from their closed episode of care. Guess what? That doesn't count for court, as it turns out, we learned today. And then there's also the very last option at the bottom of the response form is an option for you to select the box, yes, I want to staff, I have questions with the compliance department. And you can always just interrupt or call or come over, email, and ask questions, and I can staff it with you. But if you check that box, I'll pay special attention and make sure to circle back with you immediately too. But essentially it's so we know which clients are involved in the case, and if we have a release of information on file. Yes.
Just one thing is really for you and Dennis on that, because it's come up recently, certainly in the last year more than once, where a client has signed a release to DHS, let's say a hub client or a client down here in Loveland, and then they get subpoenaed. Why doesn't that ROI to DHS count?
Well, good question. And
I'm not miking you guys, so Jess, when you speak, if you get a little bit closer, and Dennis, if you could just repeat or summarize the question.
that's great. That's a great idea. I'm happy to. And Marilyn's got a good, strong voice, but you really did not pick up what. It's because it wasn't coming through my mic, I guess. But okay. Anyway, all right. So Marilyn's question is: when we get a standard form release from DHS that authorizes us to share information, to disclose treatment information with DHS. I mean, that would include everybody from the caseworker to other DHS representatives. That applies to the department. Doesn't really apply to Jennifer Stewart, who, as you probably know, is the county attorney for DHS, who does most of the court work, especially in dependency and neglect cases. She's amazing. She's phenomenal. She's extremely professional, and you all are lucky to have her. If you ever get subpoenaed on a DNN case, we'll talk about that more. But anyway, I mean, it's HIPAA standards more than anything else, Marilyn, that would require us to at least have specificity, so that when a client authorizes a person or an entity to disclose treatment information, it's more specific than DHS. It would be their attorney, and for court, because that's the other point is that, needless to say, DHS has lots of case management functions. And there's lots of treatment that they authorize and that they pay for, which is wonderful. But at the same time, court situations are different, and so we would definitely want, a consumer of yours to say, yes, I'm willing to have my most confidential, privileged, private information shared with the court in this case, or no, I don't want the information about my mental health problems shared with anybody. I want them to stay confidential and privileged.
Same on a revocation, because we do also have the AIM and Wellness Court get clients who are on probation, they've been sentenced to AIM, to Wellness Court, for example. Or not Wellness Court's not a good example, AIM, which is a intensive outpatient mental health treatment for offenders who have serious and persistent mental illness. So if they get caught, if their therapist gets called into court to testify on a revocation of their probation, and they have signed a release, a Summitstone release, to their PO, does that count?
Unfortunately, you would need, again, another, well, put it this way. I think it's true that we want to have protocols so that anybody who's on probation will immediately sign authorizations for the judge, for their own defense attorney, maybe for the district attorney's office as well, and then fourth, for the probation officer. Why? Because it's foreseeable at some point that you're going to have to communicate with all of those. Hopefully, you'll be communicating the good news that our consumer has complied with all of the conditions of probation that you required us to help them with, that is with the mental health treatment or the AIM program, your side of it. And so we want to inform everyone that this person has successfully completed our mental health treatment programs. And then of course when the people don't successfully complete the programs and they're being revoked, of course, then you've got the authority to share with the judge, the DA, the defense attorney and the probation officer or the probation department, any and all information. I mean, that's just really something that we need to foresee and to get. And then if they say, no, I'm not going to authorize all of these people to get all of this information, then the first thing you'll do is discharge them unsuccessfully, because you can't treat them under those circumstances without the ability, really, at least in my opinion, to share information with the court. Brooke?
So our releases for DHS clients already have the county attorney on them.
Oh, good.
It's a standard thing that we place on those releases, so
Good.
if they are negatively discharged from services, they already have that release in place. But I think what Jessica was saying is once a client's negatively discharged, we can't talk to the county attorney's office. Is that what you were saying?
Not totally. In other words, the Summitstone authorization or release form, of course, your release of information form might have only said, I hereby authorize Summitstone, this is the client, the consumer's authorization, I authorize Summitstone to share information with DHS. It may not say, I hereby authorize Summitstone to share information with the county attorney's office. So, it just really depends on which form it is. I like the DHS form, and I've seen it before, and you all have, I'm sure by this time, seen the DHS form, which is, again, one that you just check the blocks that apply. I hereby authorize treatment information to be shared with DHS, Jennifer Stewart, the county attorney, and then with whoever else needs the information. So releases, of course, are great. And going back to, if you will, the steps to take when responding to a subpoena, we've already emphasized that number one is to let Jessica know on the subpoena response form, among other things, who the consumer is, because the subpoena might just list the parents' names who are involved perhaps in domestic litigation of some sort. So anyway, that way, of course, as Jessica's indicated, she'll be able to identify, who your client is. But you all know the client, and so then it's going to be important, looking at our outline here. Step number one on the outline, I'm going to call this step number 1.1 or 2.0 or something, since we've already added another step before this one, but it really is to contact the client or the client's representative to find out if that individual or if those people will sign a release consenting to your testimony or consenting to the release of treatment records. And in every case, it's going to be different. In some cases, of course, we need to be able to share information with the probation department and the court to show that you've successfully completed your treatment. I think people are going to be wanting to sign that release. or if you've gotten a subpoena to testify, sorry, I'm confusing releases with subpoenas. So in any event, the point is that if you call your client and they say, who did the subpoena come from? And you say, here, I'm happy to provide you with a copy of it. That's standard protocol for us, so I'll send it to you, but the subpoena is from your ex-husband's attorney, to testify or to get treatment information for the divorce case. And in a situation like that, you could expect the consumer, your client, to say something like, well, if they want this information, I don't want them to have it. That's how conflictual these cases too often are. So regardless, the point is you find out if your client is willing to consent to the testimony, willing to consent to the treatment information being shared. And if they're not, then you document your chart accordingly. Get them to sign a release, of course, if they are. What would the release need to say? I authorize, let's just say I authorize April to testify in court on May the 4th and to share treatment information with the judge and all persons present in my divorce case. That's when, of course, they're consenting to it.
I just want to clarify.
Uh-huh.
Are you saying that even if we have a current release, we still need to contact the client?
Yes, because the release that you've had before, again, was for a different purpose than sharing information in public with a judge and perhaps a courtroom with lots of people in the room. So that's why, Trudy, that's why you would need to ask the question. Again, any releases in the past would not have been necessarily directed to judges, to a court.
Yes, our releases
Oh, you do have?
court on it.
Oh, good.
Attorneys.
Okay, well, good. No, attorneys, I'm sure. Well, put it this way. If you have a release already,
What if it's for a different court case?
well, that's a really good question too, Jessica. If it was a different court case, that supports what I was about to say. Honestly, I was about to say this. I was about to say, it may still be a situation where they don't really understand and haven't really given informed consent, Trudy, to the idea that, in this particular piece of litigation, I'm authorizing information to be shared with the courts. So if you want to call it a best practice, you certainly can. But my thought is, it needs to be specific to the fact that there's a court case on a specific date, May the 4th, we've been saying. And so, yes, we want to make sure that they really do intend that their treatment information be shared at that hearing with, the judge and whoever will be there. So now it's when clients say, I don't want action needs to occur. I mean, I don't want to suggest that it's easy if all you have to do is get a new release signed, but that's a whole lot easier than really the steps that you'll be taking if the client does not consent. So, what I've suggested in step number 3 on the first page of our outline is that if the client does not consent to your testimony or to the, again, disclosure of treatment records, then that's when you may need an attorney to provide legal advice or to take certain steps for you. Again, when clients say no, that raises the step that the court needs to be informed that I have received a subpoena. No client of mine consents to me sharing information. And so I've got a very generic blurb or very generic statement at the top of page 2 that you'll see, which says what information you could submit to an attorney who issued a subpoena to you, just expressing your objection based on the lack of consent, your client's lack of consent. And what you could say is, I have received the subpoena that you issued. I am a mental health professional. Any information that I may have in my possession regarding a client is confidential and privileged. I do not have any permission from any client of mine to disclose any information to you. That does not identify that you have a client or that, you know, the subpoena relates to a client of yours or is pertinent to one of your mental health counseling clients or consumers. But this certainly does do what we're required to do, and this is according to the court rules. When we have an objection to compliance with a subpoena, we have to state that, express that objection to the attorney who issued the subpoena. And so again, what would be the other objection that you might raise? You've asked for, well, let's just leave it at that for now. I did want to mention that again in the Summit Stone policy regarding subpoenas, there's a statement almost identical to this. And that says, because a subpoena, so this is the Summit Stone policy regarding subpoenas, which I think is excellent. It says, because a subpoena is not a release, if you receive a subpoena, you cannot talk to the district attorney, the county attorney, a public defender, or any other private attorneys without client consent. So I mean that's intended to mean, you know, you can't share any information about treatment with any of these people. Of course, that's what, you know, the release authorizes you to do when a client signs it, to share treatment information. Yes, you could still, in my opinion, send out this email, but if you prefer not to without a release, then get you know, agency counsel if you can to do that. So was that your hand up, Brooke? Or okay, yes.
Is compliance prepared to deal with all of this from all of the DHS subpoenas? Because I would say 99.9% of our subpoenas would fall into this category.
I agree. And I think it'll make it more difficult for the attorneys, and I think that's a great roadblock for them to stop subpoenas so frequently.
Because I can't think of one subpoena that I've ever received that would not fall into this category.
And when you say, and I guess I'm just not understanding what you mean by this category, Brooke.
Not consent.
I would say that none of my clients would ever consent to me appearing in court on their behalf. Because they're all in court because their children are being removed from their custody, and so their rights are being terminated.
Gotcha.
I would say the exception is this one case. One case I just got subpoenaed on, and they're releasing me from my subpoena, right?
Work is the exception to the average rule. She gives you
So, but I
No.
would say all the rest of my subpoenas are because their rights are being terminated. So at first
Yeah.
they don't want me to appear. So
Well-
I would not have a client sign a release for me to appear.
Yeah, let me summarize this for you really quickly, and then we'll talk about this specific example or situation. I mean, keeping in mind that everything that we've talked about so far is very general, but we've got all the specific information here too. So, in a dependency and neglect case, look on page 3, the third page of our handout.
When you're talking about children and GALs, I don't represent the
Hold
children,
on.
I represent the parents.
I'm sorry?
I represent the parents,
Okay,
not the children.
okay,
So I'm
all
not
right.
to a GAL.
Okay, well, you're anticipating what I was about to say, and so thank you for that. That helps, it really does. So what Brooke is suggesting is that in these cases where DHS is intervening with the family, is removing children, placing them, probably with family members, since that's the policy these days across the state, based on Colorado state law, let's try not to put children in foster care across the state. If we can avoid foster care, let's try to place children with family members. It's a great policy, but having said that, now Brooke again is seeing a mom or a dad. The DHS is trying to take away their rights, their parental rights. And Jennifer Stewart's the person who sent the subpoena to you. And if you don't have your client's consent to testify, you cannot testify, Brooke. Period.
Right.
How more absolute can I make that?
Well, that's what I'm asking Jessica
It's all new
because,
to me too.
and this is gonna be, and Trudy and Maggie and Nicole and Kirsten, and then probably all of my addiction teams, all of the clinicians that work here at Wilson, because we get subpoenaed continually for these cases. So I'm just letting Jessica know.
Well, he'll have answers for once you get on the stand.
Well,
But we're gonna stop the subpoena so we don't go to this, we're gonna try to stop that so we're not going to the stand to testify, because our clients aren't gonna sign releases for this.
well, and guess what? The judge may order you to testify.
Right, and that's probably what's gonna happen, but this is what Trudy and I are talking about here, because she gets more subpoenas than I do.
Really? Oh my gosh.
I got
Well-
3 for the next week.
Well, I mean, what value does the privilege of, privileged communications have if it doesn't mean that confidential information remains confidential and privileged unless a client consents to waive the privilege? That's what the law says. So now we just perhaps need to, see things a little differently or take some different steps. And if you, truthfully, Brooke, and I don't want any of you to have to go to court and stand up in court and say, Your Honor, I don't have consent from my client, so I cannot, I don't have any consent from any client to testify here today, period. I don't even have the ability to acknowledge that I have a client in this courtroom, Your Honor, and that includes you, Judge. So what am I doing here? May I please be excused, Your Honor? And I wish, I've almost retired from my practice. I'm about 90% of the way retired. I would like to get a job with Summit Stone and get a salary and be writing motions for you guys every day. You would not even have to pay me that much. I love this town up here. I really do. I love Fort Collins. I love Loveland. So, well, okay. I was going to say, Jennifer, could you write me a letter of recommendation, please? April, could you write me a letter of recommendation?
Can I ask a follow-up question about this situation?
Yes, no, absolutely. So obviously there's laws that apply, and there are client rights that we want to honor, truthfully. So go ahead, April.
So I'm curious, like in this situation, so say Brooke, her client is the parent whose rights they're trying to terminate, right? But the department has custody of the children.
Right.
In that case, couldn't the department just subpoena her?
Well, and well, the county does. In other words, that's what Jennifer Stewart does. So
Right.
same diff.
In that case, she wouldn't have to have consent from her client because would she? I guess she still would.
Yeah, you're right. I know. We have to think this through, and that's why they gave us 2 hours today instead of just 1, because there are a lot of issues that we need to think through, literally. But
She's testifying for the county, say,
right.
in regards to the children somehow related to mom's ability to stay clean and sober, right? Would mom still need to consent for her But to it was her testify? treatment, it's technically her treatment.
So it's still her treatment.
Yes. And her treatment information, even though it relates to the children, it's information that probably came from mom, came from the client. So it's treatment information. And I'm wondering if maybe the reason, and I'm serious about this, is that maybe Jennifer Stewart realized, well, you don't have consent from your client. Maybe I'm wrong about this, Brooke, but maybe Jennifer was thinking, I can't call Brooke to testify about her client's counseling and treatment when that client has not authorized Brooke to do that.
Another one I got released from recently was a client who was successful in treatment.
Oh, good. Okay. Oh, perfect.
I don't want to hear about that.
I don't want to hear about that.
They probably terminated the hearing or vacated the hearing because of the fact that everybody was, treated successfully. Well, here's the thing. To a great extent, Jennifer Stewart can help you with these issues. How can she do that? I'm singing her praises all day long. I really do think she's extremely professional and wants to help you all and wants to make sure you're prepared for court. And it's very possible that if you had a release, again, to talk to the county attorney, you contacted Jennifer Stewart and you said, Jennifer, I don't have a release from my client. I can't go into court and breach confidentiality. I can't go into court and commit a HIPAA violation. My client's liable to file a grievance against me for breach of confidentiality, and then what do? I don't have consent to talk to her. I'm sorry, I don't have consent to testify about treatment information, so what do I do? And then hopefully she'll say, well, let me raise it with the judge. This is what I'm hopeful that she would be willing to do, is to at least raise the question so you don't have to do it in court. I would love to be there in court to help you with this, but it ain't going to happen. So, here's the point. Jennifer could say, Your Honor, we do have a preliminary matter before we take up the testimony and this hearing. I've subpoenaed Brooke to testify here on behalf of DHS. Let her tell the judge, who you've provided services to. Brooke provides services or has provided services according to the court's treatment plan for the mom. And mom has never authorized me to testify here today. And so if mom is there, you know, half the time one or the other of the parents do not attend these hearings. I know. So if the judge sees mom there, the judge is going to say, Mom, what about that? Do you consent to Brooke testifying today or not? And then if mom says, no, Your Honor, I don't want her to testify. She helped me, and I appreciated her help, but I don't necessarily want her to talk about all the things. I don't want Brooke to talk about all the things that we discussed in treatment. So, judge, to be honest, I have to say no. The judge then has a choice. The judge can say, I'm going to order you to testify anyway, Brooke, and here's why. Parental rights are extremely important. And I would not want to terminate a mother's rights to have the love and affection of her children and to help bring them up in the world. The children that she's given birth to, unless I hear more about her and how she's done and whether she's complied with the treatment plan that I ordered. That's what they do in the DNN cases. They always order a treatment plan for every single family member. And so the judge might order you then to testify, Brooke, and say, the information that you'll have and that you'll be able to share is so important that I, the judge, want that information before I make any important determinations in this case. Or the judge might say, because the mom feels so strongly about this and she wants her treatment information to remain confidential and privileged, I'm excusing you. So Jennifer Stewart literally could help you at least to get the issue in front of the judge if there were no attorney that you had available to file the motion and to raise the issue. Brooke, thoughts on that? Thoughts on that, Brooke?
I think we're going to have to work with compliance to try to figure that out. I hope that's going to mean, because I know that the clinicians at the hub, they literally get at least one subpoena a week, most of them.
Really?
Mm-hmm.
Really?
I don't get as many as they do. I mean, I have recently. But
Okay, well let's talk about those specifically, Maggie, and let me ask you, since we haven't really heard your perspective on this, what are the situations where you're getting subpoenas, and then we'll talk to
They're the
Trudy
same
about the
one.
same thing, dependency and neglect cases?
Yes.
Yeah, okay. So dependency and neglect cases for the two of you primarily?
Is it the same for criminal cases? Like, are we talking, it's all the same rules so far?
Yes, ma'am.
Okay.
Absolutely, Jennifer. We sure are. So Maggie, any perspective you have that, you know, needs to be shared that we should know?
Well, I have to bow out because I'm very new.
Okay.
I just moved here from Georgia, and our
Okay.
releases in Georgia are, we sort of have a different protocol. We would sign a release at the beginning of treatment for the court people and the court staff, for their court worker or their caseworker. But if we had to go to court, we would then talk about the release that they would need to sign for that event. They would sign a second release
Okay.
for court. And also on the releases, there's a separate section for individual counseling where they have to consent for the individual sessions on top of everything else. So the breakdown is a little bit different.
Okay.
So what I'm learning about this process.
Right. Do you know Gail Mackey? Were you in LPC in Georgia?
I was on the, yes,
Huh, were you?
yes.
Yeah, I've worked closely with the LPC Association in Georgia,
Get the,
and I actually wrote something that I'm redoing for Colorado. It's called the ABCs of Ethics for LPCs in Georgia. I had fun doing that, I'll just put it that way. But yeah, it is. I mean, I know the composite board rules, and they're different. I like them. I can't believe that the state of Georgia has better mental health laws than Colorado does. Guess who else does? The state of Mississippi. They got better laws than the state of Colorado? Yeah, they do. They really, truly do. Protecting people's rights to mental health information more so than we do here, even though I think we have pretty good laws here. But believe it or not, Mississippi's got some great laws. So anyway, anything else, Trudy, that you want to say on the subject that we haven't already talked about?
You mentioned we should be calling client enforcing consent. One of the issues we come across is our clients change phone numbers
Oh, God.
all the time. it's so hard sometimes to get a hold of them because they no longer have their phone number.
Oh, I hear you. I hear you. I mean, I anticipated some of the questions, and one of them was the point that Trudy just made. On the fourth page of our handout, I wrote out some questions that I thought might be pertinent or that you all might want to discuss if they're pertinent to you. And so, number 3, what do you do if you cannot contact the client or the client representative? That happens way too often. I'm going to tell you what the default position is. If you do not have client consent, and you have tried, with diligence, you've reached out to the client, trying to contact the client at their last known address or using the phone number or the email address that you had for them. If you don't contact them, you don't have client consent. So the default position is, in the absence of client consent, the court needs to be informed that, I can't be testifying or sharing treatment records for someone who hasn't waived the privilege, for somebody who, has not consented to the disclosure of treatment information. So, yeah, we really got into the thick of the dependency and the neglect cases. But let's try to go back to steps 3 and 4, because I know that I mentioned just briefly, again, when you don't have client consent, you just need to communicate that to the attorney who issued the subpoena. You need to do it appropriately. If you're feeling like I don't have a release to communicate with this attorney, I can't, well, let's figure out what else we can do. But the communication needs to be made. Again, just as it says at the top of the page, just as it says in the Summit Stone subpoena policy, unless you have client consent, you can't turn over records and you can't be talking to attorneys, without client consent. So, Kelsey.
Yes, I just have a quick question. I'm sorry, you're trying to move on.
Oh, no, not at all. That's
But
fine.
Working with adolescents especially gets tough with the 15 rule. So I just wanted to ask about that.
Good.
Who gives consent in that case?
That's the great question. As you all know, and as Kelsey is indicating, 15-year-olds do hold the privilege for themselves in Colorado that enables them to consent to treatment. Privilege holders get to consent to treatment. And then the flip side of that authority to give informed consent for treatment, the flip side of that is they also, then 15-year-olds, can authorize the disclosure of treatment information. So really, the fact that they hold the privilege for themselves means they need to consent.
Okay. So does that mean even if mom or dad signs them into treatment, it's still the client, if they're over 15,
Yes.
needs to consent?
Yes, absolutely. Fist bump for you, because that's a great question. If I weren't on TV or if I weren't being videotaped, I'd be over there doing the fist bump. But no, those were very good points, very astute points, obviously, regarding 15-year-olds. Now, here's the other weird part of that. As I mentioned to the group earlier this afternoon, over at Bristlecone, this is the toughest issue for me that we deal with legally and ethically, is parents have the right to consent to treatment for their children under the age of 18. In other words, a minor is a minor until either they're emancipated because they have children of their own, for example, or until they turn 18. So because a 15-year-old can consent to treatment, does that mean that the parents don't have the right to consent to treatment? No, the parents still have the right to consent to treatment. So, the point is that when a 15-year-old does consent to treatment, the law, and boy, Jessica's great. She's already written this law, the statute on the whiteboard in the back. See where it says CRS 27-65-103. That's the law that gives 15-year-olds the authority, the legal authority to consent to treatment. And then it goes on to say, with or without the consent of the 15-year-old, parents have a right to information regarding the treatment provided, the services provided, and the services needed. I've always taken a very conservative view of this, but you can interpret those words because they're not defined in the law anywhere. You can interpret that as you will. But certainly services provided, individual counseling. You know, I've got your son in a substance abuse group. I've got your son in individual counseling. I've got your daughter, you know, in a mental health program that she's consented to, and that's it. I mean, those are the services given. If you want to confine it to that, services needed. Your son needs drug and alcohol counseling, mom, dad, you know, he's got a problem and you're going to have to help him with it and get him into treatment. I don't do that treatment, you know, for someone who, again, is not, you know, a substance abuse counselor. So Kelsey?
So just follow up to that, sorry. So normally I would be saying I cannot confirm or deny that I know who you're talking about, right? Or that I see that client. So according to the law, if they're under 18, I still have to release some information to the parents.
Yes. You know, and this is so difficult, it makes me wonder, as you say that, if somebody's emancipated and they're 17 and they've got their own kids, I would make an exception for emancipated minors. But yeah, for those who are not emancipated, who are 15, 16, or 17, yes, you can provide, again, the information to the parents that
Basic.
services given and services needed. And of course, you understand services needed much better than services given. Sometimes you can certainly, you know, provide whatever information you really think is important for mom or dad to know. You know, given that the law says you can provide information concerning services that are being given. Best thing, of course, and I don't need to tell this to you all, those of you who see adolescents, the best practice, of course, is to run it by the 15 or 16 or 17-year-old and say, I need to talk to your parents, we need to talk to your parents, I want to talk to them about the fact that, you know, you have some serious addiction problems and you need help with those. And your life would be so much better if you got some help with your drinking problems. So we're going to talk to your mom and dad about that. I have the legal authority to discuss that with them, but we need to do that. Then if there was, I mean, that's how you would present that subject. But of course, if there were another topic that you feel is, again, important for the parents to know about, you know, you can talk to your 15-year-old, you know how to do that, and to just get their permission to share specific information with parents. Again, just so you're honoring the 15-year-old's legal authority to, you know, share information or consent to information being shared with parents. Any other questions about adolescence?
So I'm just looking at your book.
Uh-huh. Uh-oh. That could be dangerous.
So I just noticed it said adolescents 15 years of age and older have the authority to consider treatment by a licensed mental health professional.
Thank you. Yes, or at a community mental health clinic like Summit Stone. But you're right, and so.
Does that mean if you're unlicensed, you aren't held to the same? They can't
What?
consent to get treatment from an unlicensed?
What page is that on? Yeah, I mean, say that again.
Page 40.
Okay, thanks.
Underneath the treatment of adolescents.
Okay, good. Yeah, because I know it's even broader than what you've just read. Statute was revised. The new law does not allow minors who are 15 years of age or older to consent to treatment by a registered, that is, unlicensed psychotherapist in a private practice setting. So what the law does allow for sure is for 15-year-olds to consent to treatment by licensed mental health professionals or treatment in a community mental health clinic, you know, a community mental health center like Summit Stone, or an other health clinic. So
kind of an umbrella for unlicensed folks to treat minors who can give their own consent.
yes, absolutely, absolutely. So, yeah, I mean, and they do make special exceptions for community mental health centers, as you know, throughout the statutes. You know, unlicensed therapists at community mental health centers don't have to be on the database. That's another exception, but anyway. Well, let's take a further look at, again, just the general steps that we're taking as we respond to a subpoena. We mentioned the fact that a subpoena to produce treatment records has to be served 14 days before a court hearing. And it's supposed to be accompanied, such a subpoena, by a release signed by the privilege holder or privilege holders. Now, when we're talking about privilege holders, and if we're talking about children's treatment records, keep in mind that when it comes to informed consent for children's treatment, when the parents are living together, nobody's divorced, either parent can consent to a child receiving treatment, medical treatment, mental health treatment. And those of you who are parents and who have children have experienced that and know that. You know, you did not have to have both mom and dad signing an informed consent form, or in our case, involving mental health treatment, signing a disclosure statement for treatment, or an MDM form here, an MDM form with Summit Stone. So let's see. When the parents are divorced, though, that's when the situation becomes a whole lot more complex, because the courts will issue temporary orders or final orders where the courts award decision-making authority either to one parent or the other. Decision-making authority meaning the authority to select a child's doctor, therapist, church, synagogue, school, you name it. That's what decision-making authority is all about. And that's why it's so very important. And when it's joint, when the parents jointly share decision-making authority, that means that you have to have them jointly consent to treatment. So each one needs to sign a disclosure statement consenting to treatment, mom and dad both. And then similarly, mom and dad would both have to sign a release for disclosure of information, again, if they share joint decision-making authority, because what we say is that they jointly hold the privilege for the children. Now, children's treatment, as we started to discuss when we were talking about dependency and neglect cases with Brooke. Brooke, of course, was talking about her examples where she's providing services to a parent. So that's a whole lot easier in terms of informed consent. But when you've got a dependency and neglect case, a DNN case, and you're providing services to a child or to children, you need to find out who holds the privilege for the child. Do the parents still have parental authority, or with children being removed from their custody, now is it the guardian ad litem or the child legal representative that's been appointed by the court in this dependency and neglect case to represent the children? Is it the GAL, or the child legal representative appointed by the judge, that has the authority to consent to treatment and to hold the privilege, again, authorizing disclosure of treatment information? You know, and that's just a general question, you know, that again does not implicate treatment information. So you've probably heard in the past, if I talk to somebody and they give me information and I'm not sharing any treatment information with them, that's okay, even if I don't have a release form. But at the same time, if you feel that the policy here is so very specific that you need a release before you talk to an attorney about anything, you know, then do what you can to get a release. I know, again, if it's a dependency and neglect case, you're going to be asking yourself left and right, who holds the privilege? That might even, I'm guessing as we strategize this, maybe it's better just to talk to people at DHS, talk to the DHS caseworker and say, can you find out for me, bless you, can you find out for me who holds the privilege for these parents? Can you ask the GAL? I'm not comfortable talking to them because I don't have a release, you know, to talk to the GAL. They're all attorneys, that is, the guardians ad litem will be attorneys, but in any case, you really want to know if it's the GAL holding the privilege. Why? Because then if you're being subpoenaed to testify, it would be the GAL, the child legal representative, who could authorize you to testify, or who could say, I'm going to object to this. And I've seen this happen up here in Fort Collins. In fact, it happened recently in Weld County. I don't know if you all heard about the sheriff's deputy in Weld County who last summer, I think, went to trial, alleged to have molested a child, one of his children. And the CLR was so helpful in that case, the child legal representative. There had been a dependency and neglect case in which the Larimer County judge that handled that case said, I find that the father has molested his daughter, and I'm terminating his parental rights. But still there was a criminal case that needed to proceed, and the child legal representative from the dependency and neglect case still was representing her client, or clients, the children, in the criminal case, and she made strenuous objections to having therapists share information with the court. In other words, my clients were the therapists, and they were being subpoenaed to testify, and the CLR was doing a great job of making sure that my client never had to testify, and she succeeded. So anyway, maybe that's a little too much information. But the point is, yeah, the guardian ad litem is the one who would authorize a therapist to testify in court in a dependency and neglect case, or in that one it was a criminal case. And she did not consent, and the judge in the criminal case was great, and he granted all of our motions for protective order, meaning motions to excuse the therapists from their subpoenas. Now let's see. We're about to get into some hugely important rules with regard to your testimony in court, but let's get to step 5 first. Oh, actually, look at the bullet point just before step 5, because here's a very important right that you all have, a right that Summitstone has, where you let the attorney who issued the subpoena know that the attorney will have to pay an expert fee for your testimony. What makes you an expert? Well, as we say in response to at least one of the questions, well, that's what constitutes an expert opinion. That's different. As we also say right here, where we're talking about fees, expert fees to testify, it says mental health professionals are qualified as expert witnesses when they testify in court regarding treatment information, and that, of course, is based on your education, your training, your experience. That's your expertise. Excuse me. Your expertise in the field of mental health. So just so you know what an expert opinion is, let's go back to question number 5 on the very last page. What constitutes an expert opinion? Because when you've testified in court, they've asked you, do you have an opinion regarding some question? To hold an opinion, an expert opinion, you have to believe that it's true, that it's probably true. The way that we say this is that it's true to a reasonable degree of to a reasonable degree of probability in the field of mental health. So if you believe that your opinion is probably true, that's an expert opinion. What you cannot do is speculate, you know, so an expert opinion is not one where you're speculating about anything. So now, again, let's take a look at step 5, which is really in court. Either objections have been made in court through a process that we discussed earlier, where in the example that we used, you asked Jennifer Stewart, could you please tell the judge that I don't have consent from my mom, from my client to testify here today, and see if the judge will excuse me, which they do. And so you want the issue to be raised. You don't want to have to be standing before the court raising this. This is why you did not go to law school. So that's not something necessarily that you would feel comfortable doing. But certainly you could go up to the attorney who issued the subpoena and you could say, look, as you know, I don't have consent from my client to testify. We've talked about that. We objected to my being here today based on the fact that I don't have client consent to testify. So would you please raise this issue for the judge so that we can get a ruling from the judge before we start today regarding whether I have to testify or not. In other words, I want the judge to know that I have no consent from any client. And, you know, the attorney should be willing to do that, just to what we call a quick preliminary matter, to raise a quick preliminary matter for the judge. You could also, by the way, you could also talk to the courtroom clerk for the judge and say, hi, my name is Trudy. I'm here today under subpoena to testify, but I don't have any client consent. And so before the court begins this hearing, could you please ask the judge to take up this preliminary matter? And that's what judges do. And that's what court clerks do. They facilitate this process. So, so that's one way to, again, get the issue raised when you know you don't have client consent and you don't want to proceed without some ruling by the judge. Now, preparation for court testimony, that's starting on the next page. So this is step 6, really, if anybody's counting. Preparation for court testimony can be provided by people like Jennifer Stewart. She's great at that, and that's why, again, I've never met her, but I've seen the great way that she's supported therapists up here whom she has subpoenaed for court testimony, and she makes sure that each and every person she subpoenas is prepared for court. Again, as I mentioned earlier, she's written out all the questions, you know, for you, so that you know what's coming. And of course, it helps her to prepare too, because, you know, assuming you do have permission to share information, treatment information with Ms. Stewart, again, the county attorney, then you can say, well, you know, I don't really have an opinion as to whether my client is still doing drugs. I mean, I don't know. I don't have a way of knowing that because she hasn't been coming to treatment. You know, she dropped out of treatment about 5 months ago, and I haven't seen her since then, Jennifer, and so I really don't know what her current condition is. But regardless, I mean, the information that you provide to her will help her be prepared, just like the questions that she'll write out for you and give you help you to be prepared. That way you're a better witness, and of course she's a better attorney, one who's always prepared. Now, you're not going to be dealing with Jennifer Stewart on every case, so again, if you have, again, consent to share information or at least to talk to an attorney, the one who subpoenaed you and the one who's going to be asking you questions, presumably in court, is the one that you can say, could you please tell me what the topics will be for my testimony? You may not be comfortable discussing all of your opinions or all of the treatment information, but at least you can find out what the topics are so that you'll be better informed. What's been the experience that you all have had in terms of success being prepared to testify in court, or lack of success in regards to being prepared?
They rarely send you questions anymore.
Say that again, Brooke.
They rarely send you questions anymore on what they're going to ask you.
And when you say they, are we talking about county attorney's office now? Might have been because I'm giving Jennifer all the benefit of the doubt. She was on maternity leave for a while. And they had some other people subbing for her who obviously weren't as diligent. But I'm trusting that with her you will get it. I don't want to mislead you. Heaven knows. All I can say is you can trust Jennifer Stewart for sure. But have you? So April, what's your experience been
I
like?
think the wild card is like the defense or whoever is going to ask you questions that you don't know what they are. You know, and obviously their job is to try to, you know, I say it's like twist around your testimony, you know, to their benefit.
Right.
So to me, that's always the hardest part, is that you may go in prepared because you had a list of questions and you have very smart answers for those, you know. However, it's kind of the other side of things that you can't be ready for.
I hear you. I hear you, and I swear in how many years was I trying cases? Probably 35. Anyway, I swear I never went into a trial without all of the questions prepared. It really helped me. It helped the experts that I would be calling and helped the witnesses that I was calling because I could let them all know. That's why I think Jennifer is so remarkable, because I didn't know anybody else who did that, you know. And was I, pretty successful in all of the trial results? Yeah, I was. I mean, primarily because of being prepared. But anyway, other experiences. Jennifer, have you had any other experiences around preparation, good, bad, and different?
I have not had experience. This is the first time I'll go to court. I went once and it was, the client kind of followed through, so I was up there and stayed up it. The case I have now is a criminal case.
Right.
So it's not kiddo involved, it's an adult.
Okay. All right. Well, like I said, if you want some brief guidance. Oh, my office phone number is on the handout, so I'm serious. If you have time, and I know you guys are all incredibly busy doing what you do, helping people, providing services and counseling and treatment to people, but if you have time, I'd be happy to, give you some reality checks, some thoughts, some ideas about, depending on who's calling you or who's subpoenaing you. Have you been subpoenaed by the DA or by the defense?
I have not been subpoenaed yet.
Okay.
I assume I'll get, I don't know actually.
Okay. All right. Well, anyway, regardless, I mean, we could certainly, at least triage that to an appropriate extent, and hopefully I can make suggestions as to how you can get prepared for court. If it were the DA's office, I'd say yes, they will help you. The Larimer County District Attorney's Office is great. They really are. And when I say great, I mean they really do want to help to protect client treatment information. When we're talking about protecting client treatment information, one of the issues that I see a lot up here, both in criminal cases and dependency and neglect cases, is this. Sometimes therapists, I don't mean anybody from Summit Stone at all, but sometimes private therapists will share information meaning to be helpful to, let's just say, the sex crimes detective who is investigating the offense that the father has molested one of his children. And so we want to be helpful, and we're going to provide, let's just say, the notebook that the client has been keeping about the whole ordeal, the whole process. This was something that a therapist, for example, might do to help empower a child, to feel like they have control over the process. So we share our notebook about the whole process with a sex crimes detective, and then the defense finds out about that, and they say, Judge, the therapist waived the privilege by providing information to the Larimer County Sheriff's Office. And so now we, in the Public Defender's Office, we in the Defense Attorney's Office want all of the child's treatment records. Well, why do they want the treatment records? As you can imagine, so they can try to cross-examine the child and make the child look like he or she is lying. So we don't want to waive the privilege. So, I mean, that's one of the reasons why we're talking about being very careful about protecting privileged information. Now, the other thing that we're really talking about doing today, I realized this really at the end of our session this morning, is we're trying to keep you all from the midst of the conflict. We want to keep you out of court if we can. We want to keep you out of the conflict between warring parties. I know that some of the cases you've talked about, there's probably no way to keep you out of that. But certainly when you tell attorneys, you're going to have to pay me if you want my opinions, my testimony, sometimes that tells them, is this really worth it? Sometimes you can tell attorneys, and this is something that a lot of mental health professionals have come up with on their own, and it works like a charm. You tell the attorney, I really can't help you. Now, I can't discuss any of the treatment information right now because I don't have a release to share any information with you, but I can tell you this. You don't want to call me as a witness in court. I can't help you. So who's manipulating who now? I mean, yes, attorneys can be bullies. We really can. They really can. I quit bullying people a long time ago. When I left the DA's office, probably. But anyway, the district attorney's office. But in all seriousness, we want to keep you out of the fray. It was, I guess I could have done this presentation in my sleep, why I did two guest blogs for AAMFT on this topic, responding to subpoenas and testifying in court. And then they asked me to do a podcast. So 4 weeks ago, I did the podcast for AAMFT. Last night, I swear to God, every time I woke up in the middle of the night, I thought, okay, what are the really important points about subpoenas that I need to make sure I mention tomorrow? But what I realized at the end of the last presentation is we really do want to keep you all out of court. We want to keep you out of the conflict to the extent that we can. When I guess it was 10 years ago, it was actually 2006, AAMFT wanted me to write an article for them for their family therapy journal, which was about divorce. And their assignment was write an article about the most frequent occurrence for mental health professionals, MFTs actually, to get board complaints, licensing board complaints. So I wrote that article, but I checked with colleagues across the country, attorneys who defend therapists. I checked with mental health professionals that I knew. I checked with licensing board members that I would meet at ethics conferences, bless you, across the country, and it was absolutely unanimous. The one thing that we see more of, and this is for sure true in Colorado, than anything else in these licensing board complaints is high conflict divorce cases, high conflict custody cases. So that's why we say we really want to keep you out of court. But if you do have to testify in court, we want you to be safe. Is there anything we need to do right now, Amy? Okay. So here's how we stay safe. There are two, I'm going to call these the two ethical rules. Let's see where these are discussed in our handout. It's under the heading of compliance with legal standards, so it's heading capital C down at the bottom of the third page. Two ethical principles apply. Number one, this is bolded right at the bottom of the third page. A therapist may, with client consent, provide testimony regarding their clinical perspective. So treatment information from your clinical perspective. Clinical perspective, that's pretty obvious. The assessment that you did, the treatment goals that you formulated based on your assessment of the presenting problem, the treatment plan that you then devised in order to meet the treatment goals, and of course the progress in treatment that you've made, plus anything else that's significant, that's pertinent. But that's your clinical perspective. Does that include your recommendations about who should have custody? Heavens no. So what is the second important ethical principle, and these did come from the AAMFT ethical standards. This is ethical standard 7.70. And it says, if you are required to testify in court, you may only testify regarding your clinical perspective, and you may not make recommendations to the court on issues such as custody or parenting time, of course, meaning visitation, time that parents get to spend with their children. Parenting time and whether it should be supervised or unsupervised. These are issues for the court to determine, but they are not, again, clinical issues. So, again, the ethical rule, and believe me, DORA, the licensing boards in Denver, they absolutely agree with this. They will discipline people who've been subpoenaed to court and who made recommendations about custody and parenting time. If a judge asks the question, I'm serious about this, sometimes they'll let somebody slide. They'll cut them some slack. The theory being, how can you not provide the judge an answer to a question? But what we were really programming people earlier this afternoon to say is, I don't have an opinion on that subject. So if a judge were to ask you, please, Jennifer, I want your opinion on this. I know that you're a licensed mental health professional. everything you've said in your testimony today made absolute perfect sense. I don't have any mental health background. I need your help to assist me in determining a very important decision. Which of these parents should have primary custody of their children? You know, is there anything that you know about the father or the mother that would say that any parenting time that they have should only be supervised, you know, down at the Harmony Center, rather than, you know, unsupervised? And you would have to say, just imagine that this is written on the wall there or the ceiling. I'm sorry, Your Honor, I cannot answer that question. And truthfully, the reason you can't answer that question is because there's a law there that's cited that Jessica's written down for us. The very first of those 4 legal citations says CRS 14-10-127. That comes right out of the Domestic Relations Code, the divorce statutes, and it says that no one can express an opinion in court or make a recommendation to a judge about custody or parenting time, or what they call the allocation of parental responsibilities, now known everywhere as APR, unless they've conducted a full-blown parental responsibility evaluation. Just so you know, that's a forensic evaluation, and it's done by court-appointed professionals, psychologists and mental health professionals, some attorneys too, but
How do they keep asking us?
I know. Oh, April. Well, I even wrote a law review article. No, I wrote an article for the Colorado Lawyer, which so far I guess I just haven't ever submitted. They haven't published it. It's in the book. It's in the legal guide. But the thought was, attorneys know ethically what they can say and what they can't say, what they can do and what they can't do. And that statute right there says you can't ask someone to testify about the recommendations for, you know, again, custody or parenting time, unless you've done this full-blown parental responsibilities evaluation. So what they're doing is setting up the witness big time by trying to lead you down the primrose path and by getting you to stick your neck out when the attorney knows full well that's illegal for them to do. So I know it's a great question, Kelsey. Don't we wonder sometimes? Don't we wonder sometimes? But anyhow.
Sorry.
But I mean, that is such an ironclad rule. So go ahead, Maggie.
Well, I've said it in court. I've said I can't give an opinion about that question because I'm not an expert in that field.
Okay.
And they are very dramatic about that you're not answering, but because I don't, I can't like make something up, or I'll say I really can't because I haven't been trained in that area. It's a pretty cut and dry phrase, but it feels better than pretending like I know what the answer is.
Well, and it's better than getting yourself in trouble too by, you know, I mean, I couldn't tell you how many times I've seen therapists, you know, who couldn't wait to express their professional opinions on these issues when they're just going to, you know, put the rope around their neck and give it to the attorney who's, you know, going to hang them. Now, they may be helping mom's attorney, but at the same time, the dad is sitting there taking notes going, oh boy, I can't wait to file a board complaint against you, you know. You've never even met me, but you're saying all these mean, horrible, spiteful things about how I'm abusive. And that's because, you know, the children's mom has told you that I'm abusive, and you've never met me, you've never assessed me. So, I mean, it's a setup for therapists, truthfully, to go to court and even to be there, you know, subject to being asked questions. So that's why I keep saying, well, we want to keep you out of court if we can. We totally do. So, Deanna?
It seems like it might be a really nice idea to have that statute just handy and be like, no, I can't because of the statute. And that's an even stronger, I think, statement that you know exactly why you're not saying it than I'm not an expert or I'm not able, I'm not informed. I think it makes you look like you really do know what you're talking about, and you still won't answer that question.
That's
why we're
that's
having
right.
this training, and we're all learning something from Dennis, especially on the compliance end. And this is why we have him here today, is to teach us these resources and remind us of what rights we do have, so we can protect you and inform you going in. So, yes, that's a good point and good feedback to have, and best believe I will have all this recorded and provided to every subpoena that gets sent to staff, and I'll be doing a little bit more debriefing before staff gets sent to court testimonies, even if you've been subpoenaed in the past. So going forward, now that we have this fresh knowledge, yeah. So
I think it's great, have it with you when you go. CRS 14-10-127.
Well, when I prepared our handout, our outline for this topic this week, I thought after I did it, that was terrible. Normally my outlines are, they look like outlines. They're just kind of bullet points and so forth. And this felt like and read like a treatise on this topic, probably because I've written the blogs and I've done the podcasts, and I'm like, I just blather this stuff, I need a life, and I shouldn't be thinking about this in the middle of the night. But, the point is, this is great to have, and so please keep this. And if you have to go to court, and if you have to testify, of course, use that as a reminder. And Deanna's suggestion is, you can write down that citation to CRS 14-10-127, and you can say, I haven't done the evaluation, or you can say another, again, suggestion that I can make for you if people are not wanting to accept your opinion, and they're being like they're being like me. They want to just persistent, doggedly asking you the question until they get the answer that they want from you. That's what lawyers do. And you can just say, look, please, I can't answer that question, as I've been saying, because I've never seen the mom parent the children, I've never seen the father parent the children, and at a minimum I would want to do that before I could possibly begin to express these or express opinions in answer to these questions. So that's just another thought in terms of how you can say no. But the point was, we really did want to emphasize that yes, you would say no to the judge too. Yes, you can say no. So anyway, Jessica.
Feel free to complete your thought on that, but Deanna touched on a good topic that we brought up at the last training, bringing documentation with you up to the stand. Can you speak on that?
Sure, absolutely. I'm betting that those of you who have testified have heard, don't bring your chart to court. Not anyway, unless it's subpoenaed. If it's subpoenaed, there's going to be a whole, again, process of finding out if the client consents to those records being disclosed and trying to get the judge to allow you not to turn them over. But anyway, aside from that, you have to take the chart, so make sure that you copy it or have somebody copy the chart. Otherwise, when they say, could you please provide me the records that you've brought here today, you've got to give them a copy of it. Again, otherwise you'll be turning over your original chart and you will never see it again. So
just my point on that was, like, we've had staff members who have brought printed off progress notes to testimony so that they can refresh their memory, because it's probably a long time ago.
Yeah.
Exactly. What was said, when was it? But Dennis mentioned in our previous training that whatever you bring up there is completely fair game. They can take it right out of your hands. They don't need the subpoena for records. So just maybe take general the details.
Amen.
They won't want it, they're not going to have any idea what it means.
Great. That's awesome, Brooke. That really is.
I am looking, are you going to talk anything about this basis of testimony and how to give testimony? But you got some great pointers.
Oh, thank you, Marilyn. This is why.
Don't lie on the stand.
Don't ignore. You can't ignore a subpoena, not unless you want to spend some time in the Larimer County Jail or the.
Well, it just when I was testifying one time in Colorado Springs, and I couldn't remember facts. There were some things going on that I couldn't remember, and I turned to the probation officer who was in the, he was at the DA's table, the PO, and I said, "Back when was that now?" And he told me after, he said, "You never talk to somebody except
That's funny.
You either look, you answer whoever's asking you the question, or the judge, or the jury. I mean, you can look at those people, but you don't go, 'Hey, Matt.'" So that was just a great pointer for me, because I didn't know that. I mean, there's a lot of things like that in every one of these you say, listen carefully to each question. Think about the answer before responding. Answer only the question that is asked. I mean, these are good pointers.
Oh, good. Thank you, Marilyn, because Guess what? I just did a presentation earlier this afternoon. I forgot to mention that chapter 3 in the book is all about testifying in court. It's a great resource for lots of reasons, but the chapter, on testifying in court, thank you for advocating it and endorsing it, Marilyn. It really is a good chapter, and it's meant to give you thoughts like, use visualization techniques, Picture yourself as being the person in charge, because you are the expert on mental health law. Nobody in the courtroom, including the judge, certainly not the attorneys, is going to know the information that you do. I will guarantee you that you'll know more about privilege and confidentiality and the exceptions to confidentiality than the court. And 90% you'll know more than, really any of the attorneys you'll be dealing with. So thank you for the endorsement of the book, Marilyn. I appreciate it. While we're on that subject, I know that when 5 o'clock gets here, we're all going to be running for the exits, especially since it's snowing. But I did bring some books for sale, discounted 33%. They sell for $45 when you buy them from the Colorado Bar Association. I can sell them to you for $30, which is closer to, what I get them for. And why? Because I really appreciate the fact that you all have had me here today. At one point earlier this week, I thought, I'm going to bring 50 books for 50 people. I'm just going to give them away. And I thought, and then you're not going to make any money off of this deal at all. That would not be very smart. But anyway, I've got some for you if you like. Now, let's see what else there is besides questions, because, I suggested a few sample questions here. Oh, absolutely. Go ahead, April.
So, if you're asked nicely via subpoena to testify as an expert in a case that's not yours, just to give education about trauma, say,
Okay.
can you say no?
Yes.
Dennis, can you please repeat that question so we have that?
Yeah, so that was an excellent question. So April has a question about whether if you've been asked to testify as a consulting expert on a case to give information about trauma, the trauma and all of the consequences that it has for children, for example, how it can affect their brain development and personality development, et cetera, et cetera. And the appropriate treatment process for it. Yes, absolutely, you can say no. The question was, can you say no to that request? And the answer is yes. I mean, that's one of your rights, is always to say no, in a situation like that. If you do say yes, yes, bill them $250 an hour, and I'm serious about that too. That's how much you would be worth at a minimum. But April's like, no, not for any amount of money, not for, no. So yeah, you do have the right to say no. And in any case, you would be an expert, you'd be well qualified, but you would simply be a reluctant expert who doesn't want to go to court. And I wouldn't blame you for that. I've testified a few times and it just wasn't my thing. I don't think I was very good at it, if you want to know the truth, at all. So what other questions do you have? Again, I've suggested just some sample questions here in the form. Jennifer.
I asked a question about a release.
Oh, absolutely. You can, in fact, at this point, ask questions about any topic that you have a question on. I'm most happy.
Do you mind if we touch on two things?
Oh,
your
a
question,
release.
I have two ROI points we brought up at the last meeting. I want to share
Yeah,
those too.
absolutely.
So I received a release that my client had signed for medical records.
Okay.
And I told the client, we've got this release, and she said, can I look at it? I guess she could look at it, right? We looked at it together, it was sitting right there. And she said, that's not what I signed, that's my signature. And the box was checked off like it was electronically, when she signed it, it was electronically, the X was there for medical records. And then it was handwritten for clinical notes. She said, that wasn't on the release when I signed it, that's fraudulent. And I was like, Jess! So we haven't done anything, this just happened this week, so.
Gotcha.
Is it fraudulent?
Well, and one of the things that Jessica wants to mention to you is the policy and the practice here too. Go ahead, Jessica, regarding revocation of releases in a situation like that.
Yeah, so that's being addressed in our compliance roadshow, which we're getting to all the teams regarding. But to revoke a release of information, can a client do that verbally?
No, you have to sign the original document.
Yeah, or a whole new release that just mimics the original document. Exactly. They have to, so I get that on date, is they have to sign the revocation piece, the revoke piece at the bottom of the ROI, or mimic the same ROI and sign the bottom saying that they revoke it. And we can't consider it a revoked release of information until we have that on file with the written request, not a verbal. The other piece about the releases of information that we spoke about the last training was there was a question for Larimer County DHS, and does it include the county attorney?
We might have talked about that when you
When I
had
was
excused
away.
yourself briefly. Yeah, because we did, and talk about the fact that, make sure that you get a specific authorization for the county attorney. And I understand that on the DHS release, that is one of the things they can check off is, county attorney and so forth. But a good point for sure.
While you guys wrap up with questions, also throw in what you took away. What was the most helpful piece that you took away from today's training? I want to see which areas were most helpful for you and good feedback for us.
One thing that I'm wondering about is other situations that you had in court where you were asked questions that you really were uncomfortable with. Let me start with you, Brooke. Have, in any of the dependency and neglect cases where I'm sure you've had to testify, has anybody ever said to you, do you have an opinion as to whether your client's parental rights should be terminated? Does it get that specific? I don't think it does, but you tell me.
A really bad one that I testified for in December, and I was not subpoenaed by the county attorney's office. I was subpoenaed by the defense attorney. The county attorney did not want me to appear.
Huh.
So that one was really messy for me. And they did ask me that question, and I advised them that that's not what I was here to testify
Thank
for.
you. Okay.
And they kind of let that go. But that was probably the stickiest one I've ever appeared for.
Okay.
And I was on the stand for almost 2 hours. And then they asked me to come back, and I had to come back again and testify, and I was on the stand for another hour and a half. So it was pretty intense.
What were you testifying, I mean, what were you saying? You had to talk for 3.5 hours.
Well, I mean, it was this, so the client had been my client for a very long time. And I was testifying about her addiction history and her compliance to that. So it was very long because I was questioned by the defense attorney and then the county attorney and the GAL. So I was questioned by all three of those entities by the time everything was said and done.
Well, and for years I've been focused on dependency and neglect cases and the termination of parental rights. What could be more important than having children, having parental rights? What could be worse than having them taken away? I can't think of too many things. So anyway, I've just really been trying to understand and find out what is the protocol when DHS, again, because it happens across the state, assigns parents whose children have been taken away and placed in either foster care or, again, placed with family members. What is the process for making sure that the therapists get client consent, well, to testify, client consent for treatment and all of that? And I can tell you there is no exception to confidentiality that would apply that would allow, again, a therapist to testify. But the other piece of this really was the question I just asked you, Brooke, and that is, do they actually ask the parents' therapist for an opinion whether their parental rights should be terminated or not? I mean,
I don't think they do that every time.
I don't think so either.
Sometimes they do, sometimes they don't.
I would totally agree. I believe you're absolutely correct. What other questions do you all have? Go ahead, Deanna.
So I'm trying to remember or see if I've got this right around the 15-year-old conversation, because that was a big takeaway for me today is, so we know that 15, you can consent to your treatment. They need to consent on the form. if the parent who also has some consent or some ability to have some knowledge or information, if there's a disagreement between the parent about consenting to disclose information for the court case, but the 15-year-old is saying, yes, that's okay, like, where do you go from there? Because 15 has the ability, so you would go with them, but what about mom?
I believe that you've stated that correctly, Deanna, that your question was, again, if a 15-year-old is willing to consent to your disclosure of treatment information or your testimony, but one of the parents says, no, I don't want my 15-year-old to be testifying in court, or I'm sorry, I don't want you to be testifying, Deanna, about the treatment information that you have concerning my 15-year-old. That's so difficult. I still say these issues are the most difficult because they're so conflictual. I mean, parents have the right to consent to treatment, and then so does the 15-year-old at the same time. And then parents, of course, naturally are going to expect that they have the right to information about treatment, while I'm going to be the voice that's out there crying in the wilderness. No, you don't, Mom. No, you don't, Dad. Not unless the 15-year-old, authorizes you to have the information, other than the services given and the services needed, which the law says that you're entitled to receive. So if I have to give a legal opinion, I'll say the specific statute controls the general provision. The specific statute giving a 15-year-old these rights controls the fact that there's a general statute in the books that says parents have the right to consent to treatment for their children, for their minor children who are under the age of 18. So I would give all the rights to the 15-year-old, but here's the thing. I mean, we know that parents can create lots of conflict and lots of problems for us when we get into these disputes. And so it becomes a legal issue, it really does. And, I think it would have to be raised with the court. Judge, I've got a 15-year-old here who says that I may testify or share information. I've got a parent who absolutely refuses to allow me to do that. You make the decision, Judge, please. I don't know what I'm supposed to do right here, right now. Which I should honor, the 15-year-old's permission or the mom's refusal to give permission. It's a great question, and I wish there were a black and white answer that we could put in the 2018 edition to the legal guide, because yeah, we'll let the judge decide, because that's why they make all the big bucks. Other questions? I've got another issue that I can raise with you really quickly if need be. It's the latest thing in the law, but other questions on any topic really related to mental health, please. Uh-huh.
I had a case where they did ask for my records.
Okay.
They were released, and then when I had to answer questions in court, they took only part of the sentence and would ask me to answer, and I just felt like it was so wrong to not use the complete sentence or even look at the context of the paragraph.
Right.
Could I have refused to answer that?
Well, that's why we're here today. That's a great question, Lori. And Lori just asked a question related to an experience she had in court where an attorney was just taking part of some statements that she had made in reports or in documents and was only quoting a part of it when it was misleading and certainly was out of context. What you can say is, could I please see that? Could you show me the exhibit that you're referring to so that I can read it?
I had a copy in front of me, so I
Okay.
knew exactly, what part of my note he was looking at.
Okay.
And sure enough, it was a couple of words out of one sentence, but he was twisting it. It wasn't in the context of the whole sentence.
I hear you, Lori. And so you've got two or three options. One option would be to say, well, I see that the statement that I made, if you'll allow me to quote it, said, and then just read the whole statement. That's one way to do it, is just to, get that out. Another way to do it, if this person's really gotten under your skin, you could say, well, you've taken that out of context. Here, let me tell you the context in which the part that you just quoted was made, and then you get to read the whole thing. So I don't advocate, I got to tell you the truth. That just violates everything I said in chapter 3 of the book. you want to be a shining example of somebody who's professional and not somebody who's going to say, well, you took that out of context.
Could we
I mean,
ask, like, can you please read the entire statement?
well, that's a third way to do it, Kelsey, and yes, you can. I mean, that's a much more professional way than what I was doing, which is,
I mean, I
You
would
took that out
definitely
of context.
go the crafty way, but I'm just trying to be professional.
But really, I do want to say this about testifying, and you guys can share this with everybody who came earlier this afternoon, because we did not make the point, but you really, truly want to be above the fray, above the conflict, even when you're in court or on the witness stand. You want to be as professional as you possibly can be. Even when you've got an attorney in your face, with the finger pointed at you, screaming and yelling and being a jerk, which will definitely alienate the judge and the jury if there's a jury in the courtroom. They hate that. They hate unprofessional conduct. So, I mean, if you've got an attorney with a finger in your face, screaming and yelling, just be calm, just be professional, you know, as the day is long, as you are, and don't take the bait, don't get down on the gutter with them. So I hope I probably didn't need to say that, but point is, I mean, keep that in mind. You know, you're professionals, and if the attorneys aren't being professionals, well, you're going to continue to be professionals. You really will. Other thoughts, other questions?
What's the latest thing?
Well, the latest thing is, a year ago, the legislature adopted a statute which authorized mental health professionals to make reports to schools or school districts and law enforcement if a client poses a threat to other students or poses a risk of harm to the school itself, to school staff, etc. You now may, I mean, the governor just signed this 3 weeks ago. It took a long time for this to get into the law books, but you may now do that. I don't know that that's something that you want to do necessarily, and here's the thing, it's not a mandated report. This is not like reporting child abuse, you know, where it's mandated. In this particular example, you may provide that information, you may not provide that information, and either way, the law, I think this is great, the law gives you immunity, so no bad things can happen. If you share the information and make a report to the school and or law enforcement, nobody can do anything. Nobody can sue you. If you don't make the report, nobody can do anything. That's the craziest immunity statute I've ever seen, but I think it's great.
How does that fit with, like, intent to harm and duty to warn?
And duty to warn. Well, that's a great question. This would be separate and apart from the duty to warn. I mean, the duty to warn is when a client makes a serious threat of imminent physical violence about a specific person or place, then that's where you have the duty to warn and the duty to initiate hospitalization of the client and to try to warn the victim and notify law enforcement.
So this applies to, like, a general statement about the school, like, I want to bomb my school.
Yes, and you don't know if it's an imminent threat or not. And really, the legislature is trying to do away with the whole idea of you have to have an opinion that imminent threats exist or that imminent harm will occur if you don't take action again to warn and protect or to report something to law enforcement. And so they're trying to get away from the word imminent as much as possible, and to allow people to make a report like this. Well, any other thoughts, any other questions? Let me just say one other thing about immunity. Whenever you report suspected child abuse or neglect, you have immunity. So no bad things can happen. Similarly, keep in mind that you're required to report elder abuse of elders who are 70 years of age or older. That's not when you suspect that it's occurred, it's when you believe it has probably occurred. Who would you report that to? Law enforcement. Not Adult Protective Services, but law enforcement, and you have to do it within 24 hours of obtaining the information that causes you to make the report. So anyway, that's just a few of the finer points. Go ahead, Deanna.
Last finer points on anything that would be different for addiction than mental health.
Not so much. I mean, I know all about 45 CFR and how incredibly confidential drug and alcohol treatment information is. I guess if we want to make a point about that, Deanna, we would just say that yes, you have to zealously protect the confidentiality of all your clients' treatment information, and if anything, you have to even go one step farther, in protecting drug and alcohol information because of treatment information, because of 45 CFR. But in any case, well, you guys have been great. I appreciate all of the questions. I appreciate all of your participation. I would have been totally bored, and so would you if I just stood up here and talked for 2 hours. So thank you guys. Thank you for coming.